everyone. So we're now moving on to chapter 4. So last week we talked about the elements of crime, criminal liability, and the elements of crime, and we talked about actus reus. So what we're going to do today is we're going to move on to another element. We're going to talk about mens rea. And then the second lecture for this week is going to talk about all of the other elements. So we are going to focus just on the rules and the requirements for mens rea. Okay, so I'll share my PowerPoint and we'll work through the lecture. Okay, so in our last lecture, we said that all crimes have elements. And in order to prosecute somebody and prove them guilty in court, the prosecutor has to prove all of those elements. And we spent a lot of time talking about actus reus. So this lecture, we're going to now move on to mens rea. Okay. So just remember that you can never find somebody guilty of a crime or find them responsible for criminal liability unless you have all 5 of the requirements for criminal liability. So remember, this was part of your assignment, your whatever for the last class. Okay, you had to talk about criminal liability. So now, just as a review, remember, you need conduct. And remember, the conduct are the elements of the crime. You need without justification. So the conduct has no valid justification or no valid excuse. Those two together make up the defenses. There has to be harm to something, and the harm is either to an individual or a public interest. Okay, so these are the 5 things that you have to have in order to hold somebody criminally liable. So we are still on the first one. We're still talking about conduct. So you're trying to prove criminal liability. You have to prove that they met the requirements of conduct. Now remember, the elements of the crime are the conduct. So in order to prove that, you have to prove all of these elements. Remember, they're like the wheel of justice. So if you're just even missing one of these elements, the wheel just stops. Okay. So you have to make sure all of them exist and you fit all the rules. We talked a lot about the rules of actus reus in the last lecture. So now we're going to talk about the element of mens rea. So what do you think about this? Joey is arrested for having marijuana in his car. It was found in the glove box. He had borrowed the car from his father. Is he responsible for this? Okay. So he did borrow the car. It was in the car, but he didn't know it was in there. It was his father's car. Should he be responsible for possession of a controlled substance? Okay. There is an old saying that says an act doesn't make the actor guilty unless his mind is also guilty. So we talked about manifest criminality last class, where you have the thoughts, but you don't do anything. You have to turn your thoughts into action. This is the reverse of that. This is when you act, but you don't really have a guilty mind. You didn't really think about it. And we can't have that. We have to have both of those occurring, a guilty mind and a guilty act. Okay, so that is mens rea. Mens rea is the guilty mind or evil mind, which means you had to have thought or had some consideration of the crime before you can commit it. Okay, so mens means mind, so that's an easy way to always remember it. So what do you think about this? What's the difference between these two? A man murders his wife for her money. His intent was to kill her. His motive was to get her money. A wife poisons her husband because he's suffering from unbearable pain of terminal bone cancer. Her intent was to kill him. Her motive is to end his pain. So the question is, are they both criminally liable? So do we have conduct? Well, we have actus reus. They both killed their husbands. That's the act. So then we have to think about, what about the mens rea, the mental requirements? Did they both think about it? Did they have an evil mind, or did they contemplate it beforehand? And the answer is yes, they both did intend to kill. Now, the first one and the second one, they had different motives for it. And one is more honorable, I guess, than the other one in a sense. But motive doesn't matter, okay? It's just, do you have the mental requirement? So don't get confused that motive is mens rea. Motive is the reason why you commit the crime. We never have to prove motive to convict somebody of a crime. You have to prove mens rea. So mens rea is, did they think about it? Was their brain functioning properly to think about it? Okay, not motive. Now, it's really hard to prove mens rea a lot of times because we don't have a thinking hat like Harry Potter and put it on and it tells what the person's thinking. So we have to base whether there is mens rea on the person's actions. And if we can prove motive, it can be a very convincing thing to a jury. Well, they were getting insurance money. They must have wanted to do it. So motive can help prove mens rea. But if you have a crime that you never can prove a motive, then it's still a crime. So like a school shooting, sometimes you have somebody commit a crime, school shootings, and they never say why they did it. So we don't know the motive, but we know that they thought about doing it and acting. That's mens rea. So just keep those straight. Mens rea is not motive. Motive can help prove mens rea, but motive is not one of those elements on our wheel. Just mens rea is one of those elements. Okay, so just like I said, how do we prove this? Because this is a mental requirement. It's in the person's head. How do we know that? We're a prosecutor and we have to present evidence at trial that the person wanted to do this. And how do we do that? It's really hard to prove what somebody's thinking. So the only really two ways that we can prove mens rea is number one, if the person just confesses and says, yes, I wanted to do it. That's pretty rare, not on TV, but in reality, it's pretty rare. So the only other way we can prove mens rea is look at the person's actions and how they acted. So if they acted a certain way, then we may be able to point to that and say, look, this is what they did. It showed that they really did want to commit this crime. They had motive. Okay, so that is one of the ways that we can prove mens rea. Okay, so this is the biggie. When we're talking about mens rea, there are 4 different levels of mens rea. So every time there's a crime, they have to have one of these 4 levels of mens rea. So if I ask you a question, what are the 4 levels of mens rea? These are the 4 you're always going to get. These are your only choices. 4, intentional or purposeful, sometimes willful, it's called. Those are all the same thing. So intentional, knowing, reckless, negligent. You need to know the definition of each because we're going to use them now throughout the rest of the semester. So what do each of them mean? Intentional. Intentional means you intend to act and you intend the result. So you intend to act, you want to act, and you intend the result. So an example of intentional would be if I brought in a gun to school, pointed at somebody, pulled the trigger, and they died. That would be intentional. I intended to act by bringing the gun, pulling the trigger, and I intended the result. I intended for someone to die. Knowing is intending to act, and the results are virtually certain to occur. So intending to act and the results are virtually certain to occur. So I bring in an automatic rifle to the classroom and I just shoot up the whole classroom all over the place. So did I intend to act? Of course. I brought the gun, I pulled the trigger, I intended to act. Is it virtually certain somebody in that classroom is going to die? Yes. So maybe I didn't intend to kill one particular person, but it's virtually certain that someone was going to die. That is knowing. Reckless. Reckless is an intending to act and not intending the result. So you do intend to act, you want to act, but you don't intend the result that happens. Okay. So you're driving down the highway, you're texting, and you hit and kill somebody. Reckless. I intended to text. I made a conscious choice to text. So I did intend to act, but I did not want or expect the results to occur. That's reckless. Negligence is just a stupid mistake. You didn't really think. It's one of those things where after you do it, you're like, oh, I just wasn't thinking, right? It's just a quick sort of thinking you should have been thinking. Reasonable people would have been thinking, but just at that moment, you just kind of had a brain lapse and you weren't thinking. That's negligent. Okay. Now, it's really important to think of these as a hierarchy. Okay. So these are a hierarchy. So intentional or purposeful is the top one. If I can prove intentional or purposeful, then I can charge any crime because it's the top fish, right? It can eat all the other fish. So if I can show they intended the act and they intended the result, there's no higher level of mens rea. So I can charge any crime. I can always charge crimes that have lower mens rea. I couldn't charge crimes that have higher. But since that's the highest, if I can reach intentional or purposeful, then I can charge any crime. If I can only prove reckless, then I can only charge crimes that are reckless or negligent crimes. I cannot charge knowing or purposeful crimes because I can't get up to that level of mens rea. Okay, so whatever level you're at, you can charge that level of crime and lower, but you can never charge a higher level of crime. So always think of it as like a little bit of a hierarchy. Okay, so let's put this in action. What do you think? A husband decides to kill his wife for the insurance money. So he runs her down in a car at 35 miles per hour. What level of mens rea is this? So ask yourself the question, did you intend to act? Did you intend the result? Did you intend to act? Is it virtually certain the results are going to occur? Did you intend to act and didn't intend the result, or was it a stupid mistake? So if you think about those definitions, which level of mens rea does it best fit? Hopefully you said intentional. He intended to act and he intended the result. Okay, so Terrence sees many people crossing the street, but decides to close his eyes and drive towards the people at 35 miles per hour. The driver is aware that death could result from his actions. He hits and kills the man crossing the street. Okay, so again, go through each of the definitions. Intend to act, intend the result. Is the results virtually certain? Which one best fits it? This would be knowing. So you intended to act, and it's virtually certain if you're driving your car and close your eyes towards people, somebody's going to get hit and get killed. Okay, next one. It's hiding my thing. So two people are driving around town. The passenger tells the driver to slow down as they approach the school zone. The driver says, "Don't worry, I know it's fast, but I'm not going to kill anyone." In a 5 mile per hour zone, the driver drives 35 miles per hour. A child enters the road and the driver can't stop killing the child. What level of mens rea is this? So intend to act. They intend the result. Was it virtually certain somebody was going to get killed? Did you not intend the result? Or is it a stupid mistake? Hopefully you said reckless. Intended to act, you chose to speed, you just didn't intend the result that would occur. Okay, that's mens rea is reckless. Last one. An 89-year-old man's driving down the road. He had a hard time seeing and hearing, and he doesn't realize this because he hasn't been to the doctor. He's driving 35 miles per hour in a 35 mile per hour zone. He hits and killed a pedestrian because he couldn't see him very well. That would just be negligent. Okay, didn't really intend to act, you didn't really intend any results. That's criminal negligence. Now, what's important to remember about all of these, they're the same facts: driving a car 35 miles per hour, but they're all different crimes. If you intentionally kill somebody, it's going to be a much worse level of homicide or crime than if it's the old man, which is negligence. So depending on what level of mens rea will affect how severe the crime or what level of crime that it actually is. Okay. So what I want you to do is I'm going to flip and I want you to read through each of the next ones and see if you can determine the mens rea. So what I would do is I would stop this and I would try to work through each of them and try to figure out which level of mens rea they would each be based on the facts. Which could you prove? Okay. And how would you prove it? So I would stop the video, work on this, see if you get it. And then when you're ready, start the video and then we'll go over them. Okay. So hopefully you just did them all. and we'll go through them. So the first one, suppose a 17-year-old babysitter falls asleep while babysitting and smoking a cigarette, accidentally starting the house on fire and burning down the client's home. Nobody is harmed in the blaze. What level of mens rea would this babysitter have? So did they intend to act? Probably not, and they definitely did not intend the result. So it would be more negligent. And then you say, how would you prove that? Well, where the cigarette was, the babysitter's testimony saying they fell asleep, things like that. So would you change your answer if she had snuck into the liquor cabinet and was drunk at the time of the accident? Maybe it's a little higher. Now maybe you're in reckless, right? You did intend to act. You intended to drink alcohol. You intended to get drunk. And then you would be responsible for the consequences. You didn't intend the consequences, but you would be responsible for them. Stone forces the lock on the Walmart store and unlawfully enters to rob the store. That's intentional, right? And how do we prove it? The fact that he actually had to pry open the lock. So pictures and people testifying about the lock being picked shows intended to act. And why would you break in if you didn't intend to steal, right? Seeking money to pay hospital bills for his child, Victor decides to take the money from his company's safe and use it for his child's cancer payments. Feeling guilty, he returns the money the next day and turns himself in. So this one's trickier. Do we care that he changed his mind? And the answer is no. We only look at the mens rea at the time the act was committed. So at the time he took the money, did he intend to take it? And did he intend to act, intend the consequences? And it was yes. So since he intended to do it and he did it at the same time, that's intentional. The fact that he later changed his mind does not negate the mens rea. It could be a defense that we'll talk about over the next couple of weeks, but it's not going to negate mens rea. Okay, well, driving, Betty's on her cell phone, texting, doesn't pay attention, gets on the wrong side of the expressway going west in the eastbound lane. She realizes her mistake too late in a head-on collision. The other driver dies. So did she intend to text her boyfriend? Yes. Did she intend the results? Probably not, okay? So probably reckless. Now, if you put knowing, is it virtually certain? I don't know. There's been some cases where they've tried to charge people with knowing crimes. It's virtually certain it will happen if you text. But I think it's a really hard case to make because a lot of people text and don't kill people. So I think it would be better being a reckless. A man leaves a bar after drinking enough to raise his BAC level, so he's drunk driving beyond the legal limit. He leaves the parking lot and drives down the street as the speed limit. As he crosses a crosswalk filled with pedestrians, he applies the brake. The pedal goes all the way to the floor and it's mechanical failure. And he slams into the pedestrian, he kills the pedestrian. So did he intend to act? Yes, he intended to drink. Did he intend to get in his car and drive? Yes, he did. Did he intend the results? Probably not. Okay, so then we're in reckless. But then what about, is it virtually certain if you're drinking and driving that you could kill somebody? That's, I think, an easier case than the texting case. So maybe you can even get to know him. So then you ask yourself, what does the brake have to do with it? What caused the death? Was it the drunk driving or was it the brakes? So that is going to be an issue in that one that we may have to deal with. That one of the other elements is causation. What caused the death? Was it the brake failure or was it the DWI? But remember when we talked about actus reus, we said one guilty act is enough. So the fact that or one voluntary act is enough. So the fact that you voluntarily drank, you are guilty or responsible for all natural and foreseeable consequences. So it may not matter that it was the brake. You chose to do one voluntary act. You may be responsible for the consequences, and it's most likely reckless. Greg and Cindy argue in front of their home. Cindy tries to walk away into the house. Greg stops her by pushing her backward. She tries again. He grabs her about the waist and she bites him. As a reflex, he just pushes her down. She falls, hits her head on a brick and dies. So this one's tricky. So did he intend to act? Maybe not, right? It was just a reflex. He didn't really think about it. Maybe it's just a stupid mistake. So the highest we might be able to get on this one is negligence. Maybe reckless if you can say, well, he was voluntarily fighting with her. So he did intend to fight. He definitely did not intend the results. So the highest you could possibly go, it would be reckless. Okay. So hopefully all of that makes sense. Okay. So what about this? Learning that her boyfriend is not being faithful to her, Mary goes to his house and shoots him through an open window. The bullet misses the boyfriend, but kills a small child playing in the house. Is Mary responsible for killing the small child? Does she have the proper mens rea for killing the child? So let's think this through. It's a murder. So most murders are going to be an intentional mens rea. So then we have to ask ourselves, did she intend to act? Clearly she intended to act. She went to the house and she pulled the gun and shot a bullet through the window. But now it gets tricky. Did she intend the result? Not really, because she intended to kill the boyfriend. She did not intend to kill the small child. So that would drop it down to reckless. But doesn't that seem weird that you have somebody buy a gun, go shoot, and the only reason why they're going to be charged with a lower offense with way less jail time is that they were a bad shot. And it doesn't seem right? It kind of is annoying. So what has happened is they have created what's called a legal fiction. They just made this up because the rule is you have to have one of those levels of mens rea. But in this case, we don't have the real level of mens rea that we need for murder. So we're going to call this transferred intent. So if we are a bad shot and we hit somebody else, we're going to take the intent that we had for the first person and move it to the person that was actually harmed. We're not going to let somebody benefit from being a bad shot or miss, okay? So it's a legal fiction because it doesn't really exist. It's just kind of, in words we're saying it. But she intended to kill the boyfriend and the child died. So we're going to pick up the intent we had towards the boyfriend and we're going to put it on the child, even though she didn't have it for the child. We're going to put it on the child based on this legal fiction of transferred intent. That's the way we then can still charge Mary with murder. Okay. Now, what about this one? John is a 22-year-old. He meets a girl at a bar. They go home together and have sex. Soon thereafter, the police arrest John for rape. It turns out the girl was only 14 years old. So all sex offenses are going to be intentional crimes. You intend the act, you intend the result. So let's think about this. John, did he intend to act? Yes, he intended to have sex with her. Did he intend the result? Well, no, because he didn't know she was only 14. She's at a bar. You would assume she would have been old enough. So he may have intended to act, but he didn't intend the result. The problem is there are certain crimes we don't care. So I kind of lied to you a minute ago and I said all crimes have a mens rea. That's a little bit of a lie because there's certain crimes that we say do not have a mens rea. Because in this case, John does not have the proper mens rea to be convicted of rape. The most you could get him is reckless, but sex offenses are intentional. So how do we still charge John? Well, it's called strict liability offenses. There are some crimes that we don't care if you have the mens rea or not. So even though I said we care about it, we really don't. If you commit the act, you are automatically guilty of the crime. So statutory rape is one of them. It doesn't matter if she was in a bar. It doesn't matter if she had a fake ID. It doesn't matter if you have a priest and a rabbi and an imam and nuns and all these people that are never going to tell a lie. And they're all in line swearing that he didn't know how old she was. And the law is going to say, well, we don't care because it's a strict liability offense. You commit the act, you are responsible. This is similar to speeding tickets. When you get pulled over for speeding, the cop doesn't say, did you know you were speeding? Oh, you didn't know? Oh, okay, you're just reckless. We're not going to give you a ticket. These are strict liability offenses. So it doesn't matter. You commit the act, you are criminally responsible for it. Those are strict liabilities. So if I ask you on the test, what is the mens rea level for statutory rape? You need to say none. There is no mens rea for strict liability offenses. Okay. So what about this? Sally went to her brother's house and says, I need to stay here for a few days. Can you help me out? 2 days later, the police arrest Bob for obstructing justice by hiding a fugitive, his sister, Sally. So she just knocks on the door and says, I want to stay there. And he's like, sure. He has no idea that she's a fugitive. So what is that? So does the law require Bob at least have some knowledge that Sally is wanted by the police? And this is what we call scienter or knowledge. And generally, yes, you require that the person have some knowledge of what they're doing, what their act is. In this case, he didn't have scienter. He did not know that she was wanted by the police. So he would not be responsible. Another time where you see this is police officers. So you're in a bar and this guy is hitting on your sweetie and he's really annoying and you won't leave her alone. So you go over and say, back off. And he says no, and he pushes you back. So you punch him in the face. Well, it turns out he was a police officer. So do you get charged with assault of a police officer? And in New York, the answer would be no, unless you knew that they were in fact a police officer. But because we require scienter or knowledge. But that is not true at the federal level. If he's an FBI agent or a CIA agent or a federal officer in any way, Border Patrol, and you punch him, you can be charged with assault of a federal officer. And it doesn't matter that you didn't know he was a police officer. You don't have to prove scienter. So you have to always figure that out for the crime. Did they have to know? Is that a requirement for the crime or not? Okay. So what I want you to do is, again, we're going to do another learning check. So I'm going to flip to the next slide. I want you to read through it and answer the questions. Okay. So this is your situation. Those are your laws. I want you to decide, if you are the prosecutor, which one would you charge George with, if any, and why? So stop the video, read through it, pick out which one you would charge and tell me why. You don't have to really write it down, but in your head, really think about, why did you pick this one over the other? And hint, it should have something to do with mens rea, because that's what we're talking about. So when you kind of read through it and you picked yours, then you can stop and pick it up after that. Okay, so hopefully you came up with your choice and you picked one of the three. So now you're saying, Mrs. Wicker, which one's right? Well, I'm going to frustrate you very greatly, because really there is no right answer. It's just what you as the prosecutor think that you can prove in court. So if you picked first-degree murder, that means you think you have enough evidence to show that he intended to act and he intended the results. If you pick second-degree murder, means you think he wanted to do the act and it's virtually certain that the results would occur. If you thought that he intended to act, did not intend the result, then that is involuntary manslaughter. And it's just which one you think you can justify with the evidence. So one of the things that's hard in this class is there isn't always a right answer, because you could provide a fact pattern to multiple prosecutors and they could all see it differently based on what their view of the evidence is and what they think they can prove to a jury. Because remember, you have to prove these things to a jury and convince a jury of the proper level of mens rea. So no matter what you picked, it's okay as long as it satisfied the proper level of mens rea that met the definition. Okay, so those are all the rules for mens rea. Now we want to be able to read a specific crime in the New York penal law and pick out the mens rea for those crimes. So just like we did it with actus reus, where we looked through the penal law, we located the elements of act and we listed them out. This one's even easier because it's mens rea and we only have one of 4 choices. So remember, this is multiple choice type of question. If I say, what is the mens rea? Your choices are either intentional or knowing or reckless or negligent. Those are your only 4 choices. So you're only going to pick one of the 4 and write one word. Okay, so one thing I wanted you to see is if you look up in the penal law section 1505, you will see these definitions: intentional, knowing, reckless, negligent. So look them up real quick and read through them. So stop the video and read through them and see what you think about them. And then start the video when you're done. So hopefully you read through them. And at this point, then I want to ask you a question. Do they sound pretty similar to what I told you? And hopefully you say yes, because the definitions I gave are really the definitions that New York uses too, okay? So this is a good thing, because if you ever forget these definitions, you know they're in the penal law and you can always look them up again. So these are the same levels of proof or definitions of proof that we use in New York. Okay. Another thing I want to point out real quick, if you read a statute in the New York penal law and it does not specifically state one of those 4 choices, intentional, knowing, reckless, negligent, always default to intentional. So if you read through it and you can't figure it out, most times it's going to be intentional, because the law is going to make the prosecutor then prove the highest thing, because we're going to protect the defendant's rights and we're going to make the prosecutor earn the conviction at the highest level. So if you read a statute and it doesn't say one of those 4, always default to intentional, always, for the rest of the class. Okay. So now we're going to actually use the penal law. So take out your penal law and you're going to use it. So we're going to use this crime, harming a service animal in the 2nd degree. It's the same one we used for actus reus. So look it up in the index. Remember, you can't look under harming, you gotta look under service animal. So stop the video, find it. Once you find it, start the video. Hopefully you found it and you were going to read through it and pick out which level of mens rea applies. Again, remember, you only have 4 choices: intentional, knowing, reckless, or negligent. So when you read the statute, a person is guilty of harming a service animal in the 2nd degree when, with intent to do so, he or she causes physical injury or causes such injury that results in the death of a service animal. So when you read that, you have to pick out which one of the 4 mens reas is required. So when you read it, hopefully your eye catches on the word intent. So that shows you intent is intentional. So your mens rea is going to be intentional. That's all you write. It's super easy. Don't overthink it. So you find the crime, you write mens rea, and then you just write whatever word fits the mens rea. So you would just simply write intentional for the answer. Okay, so you try this one. Look up gang assault in the 1st degree, read through it, and pick which one you think it is. So stop the video, write it down, and you're all ready. Start it again. So this was your assault in the 1st degree, guilty of assault in the 1st degree when, with intent to cause serious injury, he causes, and aided by 2 or more persons, he causes such physical injury. So when you read that, you're like, oh, okay, intent, intentional. Now this one's a little different. This one actually has 2 mens rea. You intend to cause serious physical injury, which is specific. It's specifically telling you what you intend. It's not just you intentionally want to act or commit a crime. You have to intend a specific act. And the specific act you're intending is intend to cause serious physical injury. So you have to intend to cause serious physical injury, which is a specific intent. And then you do intend to actually do it, which is another general intent. So intent to cause serious physical injury and then regular intent. Okay. The last one, 145, 12, criminal mischief. So read through this and tell me what's the mens rea for this one. So stop, look it up. When you're all ready, start the video again. So this was our statute: criminal mischief with intent to damage property of another, having no right to do so. You cause damage to another. Same thing. It's intentional and it's a specific intent. You have to intend to damage property. So it's not that you generally intend to act, it's that you specifically want to damage property, and you have to show that they intended to damage the property. Okay, so you would just write intentional, intent to damage property of another. Okay, so if you want, you can do these three. These are just three more that you can look up. The answers are online, so if you want to check your answers to see if they're right, you can do that. If you feel pretty good about it, then you can go right to chapter 4 assignment. Please do not overthink this chapter assignment. People overthink it all the time. You're literally going to look up the statute and write one word. So there's 5 of them. There's only one word for each of them is your answer. So don't overthink it. Just look it up and provide which word: intentional, knowing, reckless, or negligent. Remember, if it doesn't say, always default to intentional. Okay, so that's all I got for mens rea. If you have any questions, please send the questions to me. I'll be happy to answer it. And so the last lecture for this chapter is going to talk about elements, the other elements of crime, the other things on our wheel and what they are. So we'll finish up with that. So have a good day, and I will see you soon.